Hi, thank you for tuning in. Welcome to the It's Your Money and It's Your Estate workshop series brought to you by our nonprofit organization, Financial and Estate Literacy. Our mission is to empower people like you to take control of their finances, their estate, and charitable giving decisions. For the past 25 years, our founder, Peter Kote, and our entire team have been providing these free, unbiased, and accessible 6 weeks programs all over Orange County, California to help you make informed choices that align with your unique needs and values. This webinar is the second session of the It's Your Estate program. The topic is Advanced Healthcare Directive and Power of Attorneys. Our guest speaker is James Burns. Our moderator is Peter Kote. And this webinar is brought to you by Segerstrom Center for the Arts. Enjoy the workshop.
James, come on board. Good morning. There you are in San Francisco. Welcome. You're got to unmute yourself. I can't hear you.
Wanted to cool off a little bit.
Yeah, there you go. Now we can hear you. Why don't we, first of all, let's go through your Ask First form really quickly. We're not going to spend a lot of time on it. Fouad, why don't you bring it up? There it is. Expand on it just a little bit so we can see it. And there you go. You got a master's or other advanced degree. What is that, James?
Well, that's a law degree. Two of them, in fact.
Yeah. What does LLM mean?
Well, these days that stands for Large Language Models for Artificial Intelligence. But I can find it. That stood for a Master's of Law, and I did a Master's of Law in Taxation, which is getting into some specificity as to the area you might focus on in your legal career.
Yeah. I think it's the 24 years of experience. Has the 24 years of experience been in the estate planning area?
No, there was a small journey as a public defender up in the Central Valley.
Ah, cool. So you got a litigation experience as well.
Right. And got a taste of what goes on in society.
Yeah, exactly. Which kind of fits right in with estate planning because every family is a little different. Yeah. Scroll down a little bit, and there's the bar. He's licensed by the state of California. By the way, is every state a little bit different as far as estate planning is concerned, James?
I've been finding out that is the case.
Yeah.
There's a uniform probate code, which a lot of states have adopted, and then some states do their own thing, as we see in many, many cases. Through their autonomy, they're doing whatever they want and whatever they experience, and their legislators create laws that are somewhat different.
Yeah, so wherever you have real estate, make sure you understand those rules in that state, and wherever you are a resident as well. Especially important about the two documents that we're going to talk about today. Let's scroll down a little bit. You put your client's interest first, which is great. How do you charge your clients?
Well, we have two models. One is for what we call our ultra high net worth, which might be on an hourly because there's a lot of work involved in what they have to do in terms of their planning. And then I would say for the majority of clients, we're on a fixed fee. As you know, the tradition of the profession is to charge by the hour, and that gets very difficult for a lot of people to bring good quality legal care to them. So we try and put everything into one fee, and that includes everything okay. from the notary to transferring their deeds on their behalf at the local county recorder.
Okay, let me give you an example. I'm married, have one kid, have a bank account, a brokerage account, own a home. Have approximately $1.5 million estate. What would be the flat fee?
The fee for that is what we call our value plan, and that's $3,500 all in, everything included.
Okay. Oh, that's including title transfer as well?
Yes, we do it electronically so that people can have a hands-off experience in getting their home, through the recording system. Because what I found trying to do that earlier and maybe having a lower price, a lot of people didn't do that, even if we gave them the best of instructions on how to get things recorded. So what we wanted to do is make that a really easy thing, take it out of their hands, get it done for them. And often when people come in for a morning signing, by the afternoon, I'm letting them know that they're secured. Their home has now been recorded in the name of their trust.
And let's say somebody brings in a plan from another attorney that they haven't looked at in 5 to 10 years. Do you offer a free take a look, see, or a telephone call prior to engaging you?
Well, we do allow the phone call. Looking at documents, no, I can't do that for free. I don't have that kind of time available. And then I have my malpractice insurance that's given me guidelines on what to do in terms of dealing with, I call them foreign documents, which had come from a prior attorney. I cannot put an amendment into somebody's old trust without first reviewing it. It's my ethical duty. And then also it has to be run through risk management because many times people might have something that's very old and it's missing fundamental law, and I just can't accept that liability. So we have to really do a very thorough job of the review process to make sure that we're not grafting our work onto something that has a future liability because it lacks, a lot of care and, seeing a lot of different
So
documents.
what do you charge for that? Is that an hourly?
Yes.
And
Yes.
what's your hourly rate?
My hourly rate is $500 per hour.
$500 an hour. Okay. All right. If anybody has a Q&A as to how James is compensated, you can use the Q&A. But you got 24 years of experience. So that's awesome. And right now, when you practice, do you practice solely in the estate planning area?
No, we do have some corporate transactions. So a number of my clients are business owners. So we also service and take care of that.
Okay. So, which is essentially the estate planning area, but with business,
Exactly.
lots of corporate LLCs, sub S corporations. Great.
Yes.
When you're picking out, this is for the audience, when you're picking out an attorney, you want to know what kind of background that they have. So if you go to an attorney who hasn't worked with small businesses, probably not the attorney you want to see. So if you have taxation issues, like we're going to talk about next week, you'd have to have $7 million plus. You may want to see an attorney that has the LLM degree and has other clients in that category. So it's important to know a little bit about the attorney before you actually do business with them. So let's go into your presentation, James.
Okay, let me get that teed up here for us. All right, this is just a good breakthrough, a preamble, if you will, and it's really understanding California's advanced healthcare directive, the HIPAA disclosure, and a DNA. DNA stands for do not resuscitate. And a lot of people will get confused on that as to how all three of these things work and which one does what.
By the way, James could give the entire lecture for the entire series, but we're not letting him do that. We want to expose you to other attorneys as well. So I've asked him specifically just to talk about the healthcare directive and the durable power of attorney, which are very important documents in the state. But I don't want you to come out of this session thinking that's his only area of expertise.
Thank you. Just a quick personal plug, and then I'll move on.
Okay.
Again, tax attorney with 2 law degrees over 24 years. We now have over 6,000 estate plans that we've did and stopped counting after 2016. So that was the number back then. My office tends to do a lot of asset protection for the business owners. So we've saved over $100 million from lawsuits. But people have to come to us early. They can't come to me and say, hey, I've got a lawsuit hot on my heels. It's got to be something that's more proactive. I was I was honorably discharged from the United States Marine Corps. I was in its Force Recon, which is kind of like its special operations group. And then I've been an author of 2 books currently and working on a third. One's called The Three Secret Pillars of Wealth, and the other one was contributing writer for Fire Sale. It looks like that. And Fire Sale was mainly for Canadian citizens that were dipping into the US when we were having our last recession back there in 2007 through 10. And then a quick mention, I'm also a member of the Society of Tax and Estate Practitioners called STEP, and that usually means only about the top 1 or 2% attorneys worldwide in the States can join that. You have to get about 3 or 4 recommendations from your peers.
So you got some really international estate planning experience.
Yes, and we do a lot of cross-border type of transactions. Even in my own family, I have family in Italy, so I've had to do a cross-border situation for my sister that also had special needs because her son has an affliction. So that was trying, but I learned a lot in doing that.
Yeah, I've got a son in Ireland, and I'm finding out that you need somebody like yourself who understands the international law.
Yes, and a few years ago, I was seeking my Irish passport right before COVID because I can get one by descent from
You
my.
got an Irish passport, really?
No, I was seeking it right before COVID, and I haven't worked on it again, but I'm eligible.
Good. Okay, let's go to the presentation.
Real quick, here's some of the mention and radio shows and some of the publications I've been on. And then I want to first start out with that first document, the Advanced Healthcare Directive. Very, very serious document. It was kind of, all states have their version, and I know you spoke about that earlier, all states having something different. This is where things really start to differ because these are statutory driven, which means the legislators in each state kind of put together this document. It was really an outcry from a situation we saw in the 1990s. There was a girl named Terry Schiavo out of Florida, and Terry suffered a terrible stroke at 38. Her husband believed that because Terry was never going to be anything more than a vegetable, based on what all the physicians had said and their diagnosis, he thought Terry might want to go rather than be hooked up to equipment for the rest of her life to feed her and to relieve her and everything else. Her parents had a different view. Her parents obviously objected to that idea. They were very staunch in their religious convictions, and they thought that Terry wanted to live. Both sides took videotapes of the girl basically moaning and crying out and tried to portray their view. One said, no, this is a person that's suffering and should go. The other one, this is a person crying out to survive. This lasts for 15 years in the court system as family goes at it until it ultimately was decided that she could be let go. As a result of that situation, now all states have this version where you can communicate your wishes. So, this is your personal medical decisions. It even gets into your end of life wishes. Do I want to be prolonged? Do I not want to be prolonged? If I'm in a situation where it's incurable, untreatable, irreversible, maybe I'm in that coma, you're going to be able to express what you want. That way, a lot of people are relieved in feeling guilt and having to do what's necessary in that particular situation. Yeah. You're going to appoint a healthcare agent on your behalf. This even happens when people's children go off to college. You recognize that I'm no longer in charge. They're an adult. If you don't have these documents that we're going to talk about today in place, you won't have any business over their or any authority over their business. And we saw that one time when my son went off to school in Berkeley. Another guy that was an athlete got hurt, and his parents didn't have any say-so in his health care. They couldn't deal with his rental agreement at his apartment. They couldn't get into his bank accounts because they didn't have any legal authority unless they go to court. And sometimes going through court and getting all of the things you need appointed can take months.
Yeah. And you hit on a key phrase, legal authority to make decisions for another person. You know, here in California, there's a vent farm in San Diego. They call it a vent farm because people are on ventilators and they have been there over 10 years. Mm-hmm. And if you ever been on a ventilator or seen somebody on a ventilator, it's not something that you want. But will the state of California pull the plug?
Well, no.
No.
We had some legislation around the Jerry Brown administration where they were going to help fast track things almost equivalent to what we hear up in Oregon. Remember, there was a gal that suffered from terrible migraines from a tumor in her head, and she wanted to be able to leave that terrible situation. Then they pulled back on that. So, I think the deciding factor is like this, from what I've experienced, that a lot of hospitals and healthcare institutions have formed a ethics committee. The ethics committee ultimately comes down to family and lets them know we don't see any hope, or yes, here's something that we can try. And people go through that conversation. When they get to that level of there's no hope, well, guess what? They're going to start to report to insurance, and they're going to tell them we didn't see any hope. How does insurance act when they're told that there was no hope, something can't be provided? Well, they obviously want to get out, and then there can be a financial burden shift. So in other words, if a person wants to maintain somebody on life support, it may have to go out of their own pocket on that.
Yeah, but it's literally up to the person that you have picked to be your agent for your advanced healthcare directive.
Exactly.
Have you found that when somebody picks an agent, that they spend a good amount of time with them, telling them what they want, how they want to die, where they want to go? Or do they have trouble trying to figure out, if I'm talking about beyond the spouse, who to pick?
No, I think that's a great question. I don't think people spend enough time on that. I think a lot of people, because this can be an uncomfortable document, perhaps it's the most uncomfortable document during a signing, people just tend to close their eyes and just want to get through that. We always start out with this document first because I note that it's the one that just terrorizes people in some sense.
Yeah, we don't like to talk about death and dying, even though it's going to happen to all of us. So let's talk a little bit about, are you going to go, let's go through the next slide. Yeah.
Sure. Yeah. And so really, we'll just get into highlighting the purpose of this advanced healthcare directive. It ensures your healthcare wishes are respected. That's important. It helps maintain control over the healthcare decisions. Otherwise, this could be all over the map. Nobody's going to know what to do, what to say yes to, what to say no to. You're actually able to communicate in some level in this document everything that you would want if you can't speak for yourself. And remember, this document is springing, which means it doesn't really come into play unless you're incapacitated in some level.
So as long as the person can communicate with their doctor, this document is, totally void, so to speak.
Right. Yeah, it's suppressed until that time of need. And where we saw it play out a lot recently was during COVID. Well, people were on a ventilator or they're in ICU.
Yeah. And talk a little bit about, go back for the other slide for a second. Previous. Yeah, there you go. So in healthcare wishes, do people talk about hospice and palliative care and are these things important to discuss?
They're very important to discuss, and some of those elements, but in a general sense, are incorporated into the document. Much like as I get further down the road, we talk about that DNR. Again, a lot of people believe that that's all encompassed into this, and actually they're separate things.
Yeah. How does the document avoid uncertainty and conflicts?
Well, if we don't have it, just to compare it with having absolutely nothing, then we just leave it to one's mind, and nobody knows what to do. And to give you an anecdote of how that's worked out is a lot of family members can't let a person go, and they want to keep them here for themselves when that might not be in the best interest of the person who's under all of that apparatus. And I think a lot of it's centered around guilt and not having any instruction. So what this document does in essence is it gives people a pass that this is what I wanted. You shouldn't feel guilty about it because this is my mandate. And here's all the directions you need so that a person can feel good in executing this on your behalf.
When you designate a healthcare agent, what should you look for? One, and two is that how many people do you need, or should you do hey, I've got two kids and I want them to talk to one another, so I'm going to name them as healthcare agents. Is that a good idea?
Well, we try and persuade clients not to do that. And that's because I've heard from two different communities. One, the healthcare community, because we have a lot of doctors and nurses as clients. And then I also have clients that run the mortuaries. So that's the aftermath of what can happen when a person has passed. And having the co-agents both have to sign, both have to be available. Some disagree. Often while they're disagreeing, stuff isn't getting done.
Yeah.
So kind of like, as we look at it, if you were on the football field and you had two quarterbacks throwing balls at you, you wouldn't really know how to receive it.
Yeah.
So
Pick one. Pick one.
yeah, we think it's good to do, have a couple in succession, but let one person kind of do this. Obviously, they'll get feedback from everybody else, but it just makes it a lot easier in terms of being able to uh, negotiate and do all the documentation and all of the things that come with
Yeah.
doing on this.
Yeah. And make sure the person is somewhat can communicate.
Yes.
You don't want to bully. You want somebody probably local in the area so they can come and see you actually. You can't do this by phone or fax. So,
No.
those are two qualities. Do you keep this document a secret?
Well, I think everybody's a little different. Some people do.
Yeah, but they shouldn't.
No, I agree with you. I mean, this is a document you definitely don't want to keep a secret with the people you signed up for duty, and that means your agents. You want to let them know. And I think what you said, you made an important point earlier. Sometimes just having that discussion on what you really want, so that they really understand the things that are in and outside of the document.
Yeah. Should you automatically name your spouse, or does your spouse have control without this document?
Well, that's a good question. Spouses have some level of control, but it won't be detailed, so they'll fumble around to guess what you wanted also, especially when they have this heightened, crises type situation going on. And so it's difficult for them to remember what you would have wanted. I find is helpful because this reminds even the spouse, what did you want? And this document even gets into things. Did you want to donate any organs or tissues? Do you want to linger on equipment? Do you not want to linger on equipment? And it's helpful to remind even the spouse as to what the type of healthcare and the wishes that you want respected.
In my parents' case, my mother was the worst person that my dad could have picked, and she didn't like going to the hospital. Highly emotional, couldn't deal with anything. She left it up to I have three sisters. She left it up to us to do everything, yet we didn't have the power to do it. And so sometimes naming your spouse is the wrong choice, and because the spouse is the most emotional.
Right.
So you really got to kind of think through this. This is not a love document. This is literally, a medical care.
That's true. I think most people choose the spouse, but as you say, they can be the most attached in these situations, unable to, make, unattached decisions. And
Yeah.
sometimes
There's an organization called Geriatric Care Managers. I think it's called something. Well, anyway, if you Google geriatric care manager, they're actually retired nurses that work in conjunction with the agent for the healthcare to help you through the healthcare system. And they charge somewhere between $125 to $175 an hour. And if your agent doesn't know anything about healthcare, they're just a great resource to help you. Because when you go into a hospital, your primary care physician is not responsible for you. It's the hospitalist.
Mhm.
And so if you have your healthcare directive, your agent needs to know what prescription drugs you're on. They need to know what you're allergic to. So put that with your document. And I recommend highly you keep that document in glove compartment of your car and make sure your agent has a copy as well in their possession. Let's go to the next slide, James.
And so, this is just a quick example of what the most rudimentary ones look like that have been kind of fashioned through the statute. But this one would, allow you to do a couple of things, put your name and all of that to it. Here in part who your agent's going to be, put some backup agents in place. You can let people know if you have one physician or two physicians before the thing kicks in terms of the decision making. Here's different places to put your initials to authorize various aspects. So, this one you'd probably find online. Ours is a little bit more robust because we want to go into a little bit more detail, but this is just to give people an idea of at least the minimum kind of stuff you want. And I think most healthcare institutions want people to have this on file.
Yeah. Well, if you got a kid that's going off to college or, this is great. I mean, you don't have, do you need an attorney to do an advanced healthcare directive?
No, as I said, there's a lot of places you can get them online. Whether they're good or they're enough, that might be unknown. And obviously for years we've had the online document preparation services now for at least 20 years.
Yeah. Fouad, could you go back to our articles and our outline? And we'll have a couple of advanced healthcare directives there as well that people can go to. I just want to show you where they are so you can take a look at it. And here we go. There we go.
James, can you stop sharing for a second?
Okay. So there is, if you go to workshops and we have the advanced healthcare directive there. Okay.
Right here, advanced healthcare directive and power of attorneys.
Yeah.
Scroll
And
down.
general workshop documents. So we have two different forms that you can use, or you can use James or Google. We want you. This is such an important document. We want you to have it. Heck, are you still there? No, don't click on it yet. Go back. Sometimes people have a very difficult time figuring out what do we talk about with my agent. Right above it says guide your way. That's put out by the same people that did the Ask First form. And it's not a test, but it gives you a conversation starter as to, hey, what do you want me to do if I can't communicate and I'm not conscious? How do you feel about hospice? Who do you not want me to call in the event I become ill? Where do you want to die? Do you want to die in a hospital? Do you want to die at home? It's not a legal document. It just talks about feelings. And the Your Way booklet is just great. It's a check a box. It's a great conversation starter. And I totally agree with James that you need to have the conversation and it should last more than 10 minutes. There's also a document called the Pulse, and this is a physician's order for life-sustaining treatment. If you're close to, let's say you have cancer and you expect to die within the next year, look at the Pulse form, but not any earlier. And James is going to talk about a DNR in just a little bit, but I want you to realize that we have these documents online. James, let's go back to your outline.
All right. And let me just take us back to where we were.
Yeah.
All right. So now I'm going to transition over to this California Civ Code 56. It's called the HIPAA disclosure. And HIPAA, again, stands for the Health Insurance Portability and Accountability Act. Kind of came around, and a lot of people that had old trusts had to get things revised around 2004. And 2005 as the law became more pervasive. So what does it do? Well, this protects your privacy and secures your health information. And in the document here, you want to be able to name who's entitled to have authority over my information, who can call the hospital and find out what's going on with me. And this also helps, the system so that they don't have a breach in notification, because it does carry civil and criminal penalties for improper release of the information. We saw this document play out quite a bit during the COVID. Again, because of the contagious nature of the disease, oftentimes even a spouse couldn't be on the same wing or floor as the other spouse. And so the hospitals really wanted to know who's on the list that we can feel comfortable to talk about your situation. And so in this document, you could name a couple of people. Remember, this isn't making decisions for you. This is just the people that have a right to call and understand what's going on with your situation.
And the hospitals, doctors will not release any information without you having a HIPAA release.
Exactly. I mean, again, because the criminal and civil penalties are too severe, nobody wants to run that risk.
Yeah. And most of your modern documents, it contain a HIPAA release in them. So, but if you have an old one, by the way, talk about how long are these documents good for when you complete them?
Maybe a lifetime, or until you move to another state. When we have clients that move to another state, we always suggest that they at least think about changing these up again, because they're very statutory driven and state specific.
Yeah, but who do you want the documents to? That when you're in a hospital or you're talking to a physician and you have a document that's 10 years old, I mean, the physician may have a hard time, believing you that you understand what his patient wants, because you don't like talking about death, and this document is 10 years old. So I would recommend highly, although legally it's still good, you may want to have it updated, every 3 to 5 years, to like bread, it gets stale. And you want the physician to not question your belief as to the directions that you're giving.
And I would also add that there can be triggering events that necessitate a change, and oftentimes what we see is a divorce.
Oh, huge.
Spouse on there as the agent. They always say they'll pull the plug right away. Or if you see somebody in a different light where you don't see them as responsible as you thought. So, to your point, every couple of years is probably a good idea. Maybe some of those people have passed. You're no longer married to them anymore.
Or your agent moved out of town and across the country.
Yeah, geography plays a lot in it, because someone would have to be available to come on site.
Yeah. So HIPAA releases are very, very important. Let's go to the next slide.
And so, again, just to illustrate a couple of the main points of that HIPAA, it's to protect your privacy, limit unauthorized use of your information as to what kind of healthcare you're receiving, what kind of medication you might be on, promote transparency, and enable this informed consent so that people have access.
Let's go to the next slide.
And then that was our second document that we're talking about in this cluster dealing with our healthcare. And then this becomes the third one that's often misunderstood. A lot of people think that this is also integrated in the first document we spoke about, healthcare, but it's not. It's its own standalone document, and we'll get into it in a moment why. So the DNR, or do not resuscitate, it is a legal document. And what you're saying here is that I would prefer to not have any CPR or life-saving measures. Now, people often ask me, is this good for that EMT guy if I got into an auto accident, being I'm being cared for on site. It's not. That is not their job to go through this. Their job is to save life, patch you up, and get you to a hospital as soon as possible, um, still breathing with a pulse. And the hospital will then take a look at this kind of documentation. And these days, all three of the documents that we're talking about today would be scanned and uploaded into the system so that they would always be on file, no matter what happens to you and where you are.
Yeah. And the hospitals and the medical industry are starting to get computerized. So it's a little bit easier, but make sure your agent has these documents. So when they, I've been an agent for people's healthcare many occasions, and a doctor will say, "No, tell me about the patient. I don't want to read anything." so having those documents near and dear to you is really important. Definition of the DNR. Yeah, we went into that. Yep. By the way, don't do a DNR while you're healthy. Yeah. This is not the time to do a DNR. I mean, you want to be saved if it's feasible to do so.
No, true. Everybody would like to be resuscitated if they were to just, drop, in most cases.
Yeah.
But there are some conditions, and that's, the process of this, we'll look at it here in a second, is really to have a good discussion with your physician, almost like you're in confession, as to whether or not you even qualify for this. It requires a physician to sign off on this, and they're not going to sign off on just anybody. You have to have some kind of condition where,
you're in your third bout of cancer. You've had Parkinson's disease for 5 years, and It's getting worse. You've had multiple strokes. This is where the DNR comes into play.
Yeah, I think what we could say is that they would be resuscitating you back to some misery, and
quality of life is what we're talking about.
And if there's nothing to be resuscitated back to, then obviously it makes sense.
Yeah, and make sure you understand whoever your agent is, what is their religion. I was brought up a Catholic, and we had two Catholic sisters, and she was under the impression that she would be committing a mortal sin if she didn't allow her sister to go through a fourth treatment of cancer while she was 90 pounds and didn't want any more treatments, but she couldn't communicate that. So we had to call in a priest to say, it's okay. You're not violating a moral belief making a decision. So inquire about religion. Can they do what you want, not what they want, because it's your life?
It's important. And some of the things that we've seen over the years is there are certain religions that do not allow blood transfusions.
Yeah.
All of that has to be written in here. It doesn't make a lot of sense from the medical community because they want to save life, and blood transfusion oftentimes will do that.
Yeah. And your kids, or, it's good with anyone who you've named as to can they fulfill your wishes, not their own?
Well, point well said. Here's the two key elements of this document, though. It requires a physician's signature. And, what you're really doing is you're kind of solidifying in a legal document your wishes relative to this non-resuscitation.
And if you're living at home, I would highly recommend you take the DNR document to your local fire department just to let them know there's a DNR at your address or at their address, so that they don't come charging in and try to do CPR.
And that's especially important in large senior communities where the firefighters are going to be dealing with that on a regular basis.
And they pretty much know, but if you give them advance warning, it's really really important. Let's go to the next slide.
Again, reiterating that there is a physician role in this. So oftentimes people think that this is a document an attorney can do for them. And it requires the physician to participate in it and sign off on it and counsel the person and put them through a checklist of questions to make sure that they qualify.
Yeah. Just remember, though, when you go to the hospital, your personal physician is not going to be there. Okay. Your primary care physician, you'll have a hospital list, and they don't know anything about you as the patient.
No.
And so that's why it's really important to have that advocate, to be local. Your agent needs to be around, at least within the next, in an event, at least within 2 to 3 hours, if not in less than an hour.
Agreed.
Okay. Hopefully most of us do not have to worry about DNR.
Right. No, it's not for everybody. We can put it that way. But
Yeah.
but if you are out there and it is for you, here's the steps. You begin a discussion with your physician. Then they're going to evaluate based on knowing your medical history, whether or not you qualify for such a thing. Then you're going to have some paperwork drawn up. You're going to review that paperwork after discussing with your physician, and then you're going to complete and submit that. And as Peter alluded, where are you going to submit it? Well, one place might be with the local firefighters if you live in a large senior community, or this is going to be with all of your other paperwork, which a lot of times these days is scanned and digitized and uploaded into the system at most of these healthcare organizations.
Or if you're living at home, put it on the refrigerator, or somewhere where someone can find it on the door. But again, let's go to the next slide.
I would say also with these, there's little bracelets people can get that help identify this.
Yeah.
So here's just walking us through all three of these documents and the differences. So the difference between the DNR, the Advanced Directive, and the HIPAA. So again, the DNR, it's a specific order that instructs healthcare providers not to perform CPR. That's really its main function, and it requires a physician, and you have to qualify. You must have a condition that would qualify for that. Otherwise, saving life is the Hippocratical oath of most medical professionals. The Advanced Healthcare Directive, it's a broader document that takes into account specifics like, do you want to be prolonged or not prolonged? Do you want to donate organs? Is there somewhere in there that you would like to give people an indication of your preference for memorial services, be that burial or cremation?
Huge issue for family members,
Yeah.
So discuss it. And by the way, you're going to be dead. So you may want to ask the family what they want. Do you want a ceremony? Do you want a celebration of life? I get questions on an obituary. If you want an obituary, write one. Put it with your estate planning documents, and we'll get it published. But they call it the Advance Directive. So you need to put a little bit of work in it prior to you dying.
Exactly.
And then let's go to the next slide. We got about 30 minutes left. I want to get into the durable power of attorney for finances.
Okay, we're going there. But real quickly, the HIPAA, again, just regulates disclosure and protects your healthcare information. Yes, and then we proceed into that durable power of attorney, which means, unlike the limited power of attorney, which sometimes between spouses, someone gives the other while they're going to be on a trip in maybe another country, and they need them to be able to sign documents on behalf of the family. This is enduring and durable, which means
it's financial.
Yeah, and true, it is a financial power of attorney. You will appoint an agent. There can be a broad decision-making authority in here so that they could talk to governmental bodies, financial institutions, everything down to your DMV, which sometimes it comes down to dealing with somebody's automobile, and nobody has, again, legal authority over these things unless we empower them with this particular document. Now, the alternative to not having this document, if somebody has to go out to the court system and seek a conservatorship over you, which can be lengthy and costly. And sometimes timing is a critical factor. I had a client a number of years ago. He had a stroke, and the next month was when all the .coms turned into .bombs. It was May of 2000. Well, Well, his portfolio manager had him still aggressively in a lot of tech. And guess what? It was going down by the minute. Had his son not had this durable power of attorney, a letter from his neurologist saying that dad had this stroke, and then his own identification, he was able to go to the broker and get him to move him back into cash and save what he had. And that's expediency, being able to take action right away. If son would have had to go to the court system, even under exigent, which means emergency circumstances, he could have still been in there for days, weeks, months.
Can a spouse, let's say each spouse has an IRA account. Can one spouse get into the other spouse's IRA account without this document?
No.
So even between spouses, they need this document.
Right. In our document, we allow spouses to do some gifting and some retitling so that their afflicted spouse could qualify for the Medicaid system. Without that, you have a powerless power of attorney if somebody can't take those kinds of actions on your behalf.
So how title comes into play here? You mentioned the son and the father. So the father must not have had his assets in a living trust.
No.
Yeah, so he had them in his own name.
Yes, and that's a good distinction. Where this really comes into play is when things are outside of the trust. Otherwise, a co-trustee or the successor trustee is acting for all assets that are under governance of the trust. And this covers everything outside of there, which might be a portfolio that's not in the trust, a bank account that's not in the trust, or anything else. Like your
I had to change somebody's Cox cable services. They would not talk to me until I showed them the durable power of attorney.
Right. It's being able to do all those activities on behalf of the other person, which normally they wouldn't be empowered to do.
Exactly. The legal authority.
And the most important thing on this slide is no court intervention required. So on every state website where they talk about conservatorships, they name this particular document as your only tool to not have to go through the court system.
Talk a little bit about appointing an agent. Who should you appoint?
Well, that's a good question. Most people go through this and they want somebody usually that's honest, is the first thing. Somebody that they feel has a little bit of financial acumen, but I think the most important comes down to somebody who's honest, because in this state we have a lot of elder abuse, and when people are caught in the other side of the system, which is the conservatorship, the reason I said it could be expensive and lengthy is because of the level of elder abuse that goes on in the state.
Yeah, it's the fastest rising crime here in Orange County. It's just amazing. And by the way, speaking of financial elder abuse, when you open up an account wherever in your own name, and you have a durable power of attorney drafted by you, the attorney, what happens at a Wells Fargo or a Bank of America? Do they have to accept your drafted document?
No.
Yeah, it's amazing.
Well, let me, and that's obviously the knee-jerk answer, but well, in essence, they should have to, because provided by code, it's law. And oftentimes we run into some of that opposition till we educate them, because a lot of places just, aren't trained very well on these.
Yeah. And they want you to use their durable power of attorney for their account at their institution.
Right. And sometimes we ask those institutions, where's that provided for in the code? And they can't quote it, but they say it's our internal policy.
Yes. And they use the excuse that there's so much abuse that they want to make sure that they're not on the line as far as liability is concerned. So if you have your durable power of attorney, make sure you take it to your financial institutions and say, hey, will you accept this document? And you do it while you're healthy and alive and cognizant, and then they'll take that attorney drafted document and put it in your file.
I think that's great advice because, I mean, how do you find out how well these documents work? Well, you either die or you go get incapacitated, and then we know. And
Yeah.
we don't want to wait till the last minute. So it's a good idea because we have seen opposition with certain institutions saying, we have internal policies, and you just want to make sure, does this state mandated, completely compliant document fit in with their internal policy?
And then there's some institutions that will not accept a document that's over a year old. I mean, that's not the law. The law says it's valid forever.
Right.
But the institution says, hey, as a policy, we're not going to accept your document because it's too old. So
Right.
get it filed with these financial institutions as soon as you can. And remember, this particular document is for assets that are in your own name and also assets that are in your retirement plans, 401ks, 403bs, 457s, SEP IRAs, Roth IRAs, etc.
Mhm.
You have to have this document.
That's a great point because those kind of instruments would be outside of the trust governance, your retirement plans, anything deferred,
Yeah.
annuities.
And for a married couple, each one of them has to have their own,
Correct.
and how many people do you usually name in these documents as successors?
Well, it's different for everybody. A lot of people struggle to find people that they feel comfortable with doing this. But we want them to always have two
At least two.
details.
At least two. And because it's financial, would you recommend that they pick the same person as their trustee to be their agent for their durable power?
Again, that's dependent upon, who do they have to select from? And geography, because this one is probably more intensive than anything else. This is the one where you could be a little bit fuzzy, maybe a lot fuzzy, and you need somebody to help write checks, help you keep your bills straight, deal with contractors, people that would come to the home and maybe try and rip you off. A number of things that are just geographically driven. So you need,
Yeah.
so
Yeah.
that really comes into play here.
I would never, we don't put these forms online. Please don't go to a stationery store and buy one of these. This is such a powerful form. You need an attorney to sit down with you and draft this document because of the power it has. It's your money. And you want somebody who's going to be careful with it. This is one of the more abused documents out there.
Agreed.
Yeah. So creating one, please make sure you have an attorney draft one for you. Activating one, what does that mean?
Well, activation, there's two types of this durable power of attorney, so let me distinguish. There's one called immediate. Oftentimes spouses will do that, which means it could go into effect anytime they need it and it's existing. And then there's springing. And springing means it's only going to come into effect when the person's been declared incompetent. And that means by examination, usually from neurologists or psychologists, that they don't have the cognitive capability to discern legal, financial, or business matters any longer. And for their own safety, they must describe them as being incompetent.
Yeah. So this is another one of the most important matters that you need to look at. Do you have an immediate power of attorney or do you have a springing power of attorney? When my mom was 92 years old, the last thing we wanted to do is go to the doctor's office and have her declared that she lacks capacity in order to have the document spring into power so that we can use it with her to write her checks.
Right.
And I'm advising, and I don't know what your general philosophy is, James, but those people who are over 70 and have a trustworthy purpose, are you doing immediate powers of attorney?
We do have that conversation with them and recommend that. And here's the reason why. I've had too many situations where a person that might have really good cognitive capability, but physically they just incapable of getting in for a meeting. They're not mobile, and
Yeah,
the kids want to help out and do something on their behalf.
yeah,
They need that immediate power of attorney because they're not going to be declared incompetent because they're too good upstairs. And
yeah.
so there can be that gap and a struggle to get stuff done.
Yeah, and the medical industry today is such that they're concerned about liability. And
Exactly.
so I highly recommend immediate. Sometimes if you do a medical opinion letter to spring the legal authority into action, please only use one medical doctor. Don't use two. One is hard enough. If
Right.
you two is sometimes it could take weeks.
Exactly. If you can even get them.
Yeah. Okay. One of the questions that we have is, does different institution needs its own durable power of attorney? It's institutions want you to use their durable power of attorney because they know it, and they don't. Attorney drafted ones, they're not familiar with it. So they want you to use your own. CalPERS, for example, wants you to use theirs. But a POA or power of attorney, by the way, always make sure it's durable. What does the term durable mean, James?
It means it's lasting. So that
Yeah, through incapacity.
yeah, it's meant to be around and available, without without a termination on it other than your passing.
Yeah, but even if you use a bank's or financial institution's durable power of attorney, you should still have your own drafted by an attorney, because insurances, Verizon or your telephone, cable, so many areas that you have to make financial decisions for another individual.
Right.
Can a durable power of attorney be used with the agent being out of state? Uh, no, I wouldn't. I would think it's not recommended, but what do you think, James?
It's not recommended, but certainly sometimes that's all people have. And then, as something that's an outcry of the COVID type era, a lot more agents can do what we're doing right now. We're even coming on to, we have legislation to do that with notarization of documents going forward. We can do this. I just had to do that with my sister's trust in Italy. We both did online notarization, but then you have to send it to the state for apostilles to make sure that the state verifies all of that.
Yeah,
So I
it's
think,
an extra effort.
so I think somebody could do it like this. They might ask them that, to hold their ID up, in front of the screen so that they can capture that, but it's not.
Wouldn't recommend it.
No.
Wouldn't recommend it. Life insurance, an absolute necessity. You need because all assets not titled in the name of the trust needs a durable power of attorney. So this document is huge, and everybody needs one as part of their package.
Yes.
We talk about a package being a will, a durable power of attorney for financial affairs, the advanced healthcare directive, and the living trust. So everybody needs one of those, and hopefully you'll beginning to understand why these documents are so important. Once activated, I'm going to your slide, James, utilizing the durable power of attorney. Once activated, agent can make financial, legal, and healthcare decision on behalf of the principal. What is that person called? Is it called the agent, or how are they? What's the legal term?
Well, they are called an agent, but the more
Attorney, in fact.
exactly, that comes from an old age period. And in fact, when we execute this document, especially between spouses, one spouse will sign on the other one's accepting their duties as the attorney. In fact, most states have gone to that model. I had done plans for some friends in Wisconsin, and that was the first time I saw that many, many years ago. But now California also has that.
Yeah. Let's go to the next slide.
And why you should have it. I don't know. I think we kind of,
Well, yeah, well, I think it's worthwhile. We think of these documents as always being at death. I'm sorry. You're dead. No more worries. You're gone. Most estates settle because everybody wants their money. But man, if you're alive and you're suffering a stroke or a Parkinson's or Alzheimer's,
Mhm.
I mean, incapacity planning, from my point of view, is what this is all about because you're living and breathing and you're dependent on other people to get the quality of life that you deserve. And so spend some time on possibly incapacity. And you got to have that durable power of attorney to do that.
That's right. We used to always refer to this situation as the living probate because we're in probate court while the person's still living, but they don't have that capacity. And it's something we just learned in the last couple of years is that they used to believe Alzheimer's was a subset of dementia. And now they have people getting diagnosed at 38 years old.
Yeah. And let's say the person doesn't have the durable power of attorney or an advanced healthcare directive. What do they do?
Well, if they're found in that situation, someone will have to go through the court system to get appointed, and we usually call that the conservatorship, and
Yeah.
guardianship. But in California, it's more formally known as a conservatorship. And I'm sure you've been through a couple of those. They can be lengthy, costly. Maybe some of your private information becomes public record because it's in the court system.
Well,
And
that's your least of your concerns.
right.
It is so expensive.
Yes,
$10,000 the first year. That's minimum. That's if there's no controversy.
right. And then
And finding an attorney who will do it because the process is becoming so complex.
right. A few years ago, we analyzed it for an average one through Los Angeles, and it was $20,000-$30,000.
Yeah, easily. So if you don't have this document, then nobody can get into your bank account without legal authority. And so to get that legal authority, if you don't have these documents, we have to go to get a court order. And just to get heard today in Orange County, it's taken 3 to 5 months,
Mhm.
just to get into court. That's not even having a court order, just to be heard. So this incapacity planning issue, from my point of view, is top notch. Financial management. I would say, you could do it with a durable power of attorney, but have a living trust.
Yeah,
Wouldn't you say, for financial management?
right.
It's kind of the durable power will allow you, but there's so much fraud with the durable power that it has to go through the legal counsel of all these financial institutions. It's not a great way, but it can be done. So avoiding car guardianships and conservatorships. The advanced healthcare directive is for the person, right?
Right.
So you have a conservatorship for the person. And then under the financial stuff, you have a conservatorship for the estate.
Yes.
And so you can have the same person be both, or you can pick different people. But again, in your documents that you draft, James, do you include who the person may want as the conservator?
No, because we're trying to keep them out of that conservatorship
Okay.
altogether.
Okay. Flexibility. Do you often put the power to gift in a durable power of attorney?
We do. And that's strategically placed in there again if somebody needed to go into long-term care and nursing, so that the other spouse would have the ability to gift things off of the personal balance sheet or go and retitle the income off of, say, an IRA so that the person can meet the eligibility for the minimum income for the Medicare system. A long
Yeah.
time ago, there used to be powerless powers of attorney that that limited this to only the annual gift exclusion. So, and we only like to give this between spouses. We don't like to give it to any other parties because we think it can be abused there.
Yeah. Some financial institutions want to specifically state that retirement plans are in that document. So these documents have to specifically state what powers your attorney, in fact, will have.
Exactly.
And you mentioned something about the when we started this, James, about, hey, I'm leaving the country on vacation. Where does the power of attorney come in to that?
Well, what I had experienced in my career is I'd have, very active executive clients, many of them in sales that would be traveling international. And we were at a period of time when people were refinancing mortgages all the time. They wanted to capture that rate. If you're not there to sign, then you'd lose it. So they would typically leave their spouse at least a limited power of attorney, which means for a shorter period of time and for a specific purpose. So it would have those two things spelled out on it so that the spouse could execute on your behalf while you're out of the country.
Yeah. So you have limited powers of attorney. You can limit it to time or to an event, or you have a durable power of attorney, that you need as part of your estate plan package. Proactive planning, you absolutely, when you update your plan, your durable power of attorney needs to be updated as well. You want it fresh. Mm-hmm. You don't want an old one and that your financial institution is going to reject.
Right. Sometimes people would have brought some in that were probably from like a stationery store. You remember they used to sell those.
Yeah. Yeah.
I don't do it anymore because there's liabilities in it.
Yeah. It's for a typical estate plan. There's no such a thing as a typical estate plan, but you can't put all these documents together in 1 hour. How much time do you spend with a client putting a will, putting a durable power, putting a living trust, the advanced healthcare directive? How much time on average per client? And for a married couple, you got to, it almost doubles that time. But talk a little bit about that.
Especially if they're an engineer.
Oh,
but I would say on average, the life cycle is probably 4 hours or so.
Yeah.
Because we're going to go in there, and then these days we have software that helps produce the first generation of the documents, but then we're using artificial intelligence that will go over it and make sure that it's incorporating some of the latest language that judges have professed in their holdings and cases, or create those clauses that emulate what was a holding in a recent case, so that it has the latest build out.
Yeah, but that's where that 24 years of experience comes in. Let's go to the next slide.
Get into the responsibilities of that agent. This is big stuff. High fiduciary duty. One really has to act in the best interest of the other person. Maintain
may not want a person who just declared bankruptcy.
Never. Anybody who's desperate, might not do the right thing, and we've seen a few of those unfortunate situations over time.
Confidentiality. If let's say you got 4 kids and you name one of them, they got to keep it. That confidentiality could be an issue.
Exactly.
Oh, if you don't have, the best person sometimes is the person who is really anal, because look at that. You got to maintain accurate records.
Right.
It's just everybody wants to know how you spent the money for the other person, and they're entitled to know.
Right. And as if in that fiduciary position, which is the highest duty and has some severe consequences for violating, you want to make sure you're keeping your records.
Yeah. Yeah. Um, conflicts of interest, boy, that's a big one.
Right. So sometimes, an agent might, let's do an example. Maybe somebody's acting as your agent. They're also a real estate agent and they want to sell your property and make a little commission on the side there. And so those things should be avoided. And if not, they'd have to be thoroughly disclosed to everybody else of interest. Maybe those are beneficiaries and get everybody to sign off on them, which is a lot, which still, is a lightning rod. So it's best to avoid those conflicts when you're acting as the agent, the attorney, in fact, not to double dip.
Yeah. And boy, the last one here, that is so important here. And I find that sometimes males in families don't understand this. You got it. It's not your money. It's the agent's money. It's the principal's money. And so yeah, the agent must comply with the instructions. That's huge.
Right. It's like if you're driving down the road, you don't just hop off the road and go 4x4 unless you got, a four-wheel drive.
Yeah, it's just very good slide. Let's go to the next one. We have about 5 minutes left.
Okay. And so we'll kind of move through this. This is, again, just some examples. This was the older style where you would fill it out. I'm going to make note on this one. This is nothing like what we have, but these are examples. And the old style used to be a person would initial each power that they want to leave a person, or they would just go down here to the very last one and initial there and say, I'm giving them all the powers. Again, these are good, but they weren't really specific enough to get into all the details. And as you said earlier, they didn't talk about each and every one of the assets. It didn't talk about each and every one of the governmental bodies that you would be empowered to speak on behalf, even getting into DMV. As you know, sometimes, especially for a senior, a car may be an issue. How does one talk to DMV without some legal authority?
I try to avoid DMV like the plague, and luckily there's Auto Club. So
Yeah.
speaking about cars, how do you handle that? Should that be part of your trust, or how should you have title to your car?
Well, we don't think it is in most cases because it's a highly depreciating asset and the transfer is fairly easy.
Yeah.
To a DMV form and a death certificate, and you decide whether you're going to zero it out in terms of what it was sold for, or a dollar, or whatever that is.
Yeah, if you're husband and wife, do or Jane or Mary or whatever. So it's not really considered part of the estate. It's handled completely separate through the DMV.
Right, and it doesn't meet the threshold for probate, which is about $188,000 now. But occasionally we do, about 2, 3 times a year, we do have those vehicles. A Rolls Royce, a Lamborghini, a Ferrari comes in, and we're going to do something different. We're usually going to have that titled into an LLC. It might be out of Montana. Montana is the biggest state in the country for transferring those luxury vehicles, maritime vehicles, and even aircraft. You can go to a little podunk airport there, and these Gulfstream 5 are changing hands. So that's what you do on the high end. But everybody, your cars are all nice. Every one of us has a nice car.
Yeah.
But fortunately, the minute we drove it off the lot, it begins to lose significance.
Yes. Lose value. Let's go to the next slide.
So it's a not to worry. This we get a question about this almost monthly because we had a pretty good blog article on it. So revoking your power of attorney, because sometimes somebody might be going rogue.
Yeah, this is not the document you give out freely.
Right. And this usually might be the immediate one. So this is when the immediate one might be going a little bit down the wrong path in terms of the agent abusing it. And so really simply all really one has to do, there's no real formal process other than you might want to prepare a writing and say, I revoke this. And then you want to send that to the person that you had as your agent. And then every financial institution that you do business with, you want to let them know that I hereby revoke that power of attorney so that that person can no longer use it.
Yeah. Yeah.
Those 2 steps, write that agent, say, hey, I revoke your powers, and then start sending another letter. I revoked Joe Smith's power as my agent for my durable power of attorney, and they should no longer have any power over my affairs, and send that to the institution.
Let's go to the next slide.
And that's it.
That's it.
All I have.
Hey,
for
we're right at 11:27, so we're right on course.